SJC-12154, Commonwealth v. Keron M. Pierre.
Mr. Black, you may begin.
Okay, I got the phone up to my ear now. Is that better?
That's a little better, yes. Thank you.
Okay. I still have a scratch, but I've had that scratch in my throat for about a month, I think, because of allergies. So
okay.
I'll do my best. I'll do my best.
We do hear you loud and clear, so go ahead.
Okay. Thank you. First of all, good morning, everybody. My name is Attorney Alan Black. I'm representing Mr. Pierre in this matter. I hope everybody is, sincerely hope everybody's in good health and doing well during all this time. Just want to say, I think I argued 5 issues, including the 233 issue, but what I would like to do is just very briefly go over this case. It was a shooting. It seemed like it was a spontaneous shooting that occurred March 29, 2009, where somebody, allegedly the defendant, went up to a gun and started firing a significant amount of shots into the gun, killing 3 people and wounding a 4th. The firearm was never found. There's no, I would say there's no forensic evidence tying into the scene. The gun, actually, I'm wrong. The gun was found, but the gun was not found on the defendant, was not found in any way forensically linking the gun to the defendant. It was found on another individual who probably had no connection to the actual shooting. There's no evidence that this man was there or present. The issues that I addressed was, one, because of the lack of forensic evidence and because of the lack of a statement or lack of a confession. Now, we did testify at his trial, and I'm going to go into that in a minute, but there were evidence of 2 separate incidences where the defendant placed a black firearm on a table. 2 different individuals, a Denise Stevenson and a Mr. Clouden, and essentially threatened them. The firearms had nothing to do with the incident. It was stipulated that those firearms were not the murder weapon. Yet, those were over objection. They came in anyway. There was a contemporaneous objection as to, there was a motion in limine to bring it in from the Commonwealth, and that was objected to. It was contemporaneously objected to as to Mr. Clouden, I believe, and not contemporaneously objected to upon the admission of Miss Stevenson, when that came in. There is a very interesting Commonwealth versus Day issue where evidence of a grand jury testimony of this particular individual, Mr. Johnson, was allowed to be read in front of the jury, and it was introduced substantively, even though Mr. Johnson said he didn't really say those words to the grand jury. He got the information that he said to the grand jury from somebody else. The police came to him and, according to Mr. Johnson, threatened him that if he didn't testify, he would be subject to charges. But he said he did not see who the shooter was, and that was objected to by defense counsel. There was an interesting issue that I put in because I was a little, frankly, if it matters, I was a little offended by it. But it was a Davis versus Alaska case where Mr. Leacock testified that he was being charged in federal court for bringing $400,000. Blue Logan, and he was being charged for it. And there was a motion in limine by defense counsel to allow himself to impeach him pursuant to Davis versus Alaska, even though it wasn't related to the case. However, Davis says absolutely you're able to testify that he had maybe an expectation that he could get something off. In the federal court, as you know, you can get some kind of points off if they find some cooperation involved. Yet all of a sudden, right before the defense counsel withdrew his motion in limine, I'm not sure why. That was never brought out, but I argued substantial miscarriage of justice. Mr. Leacock was an important witness in that, whether he was facing, he was expecting some kind of favorable disposition in federal court would have been biased and would have been appropriate. And then finally, there were two issues related to the fact that when Mr. Pierre testified, they repeatedly, and I say repeatedly, asked him he was in Trinidad, and repeatedly asked him, why didn't you come back to the United States and clear your name? Over and over and over and over again. At some point in time, the judge interrupted and said, listen, instructed the jury, you can't, he said the question was proper, it goes to credibility, but you can't hold it against him if he didn't come back. I argued both constitutionally under burden shifting and also under Nickerson in state courts in our SJC's case law regarding pre-arrest silence, pre-arrest silence as to be used against them. And that's our case. So I'll be quiet.
Well, no, we're not going to ask you to be quiet. We're asking you to be responsive to questions, but we'll start the questions. Justice Lang?
Hi, Mr. Black. Good morning.
Good morning.
Yes. My first question has to do with what was the theme of the defense, please?
Excuse me, I couldn't hear that.
I asked you what the theme of the defense was.
The theory of the defense?
Yes, please.
Well, that is a very good question.
Yeah.
And I'm not trying to be facetious. I think the defense was that it wasn't him, but that did it. And the credibility. What you've got is two witnesses. One witness that was able to testify to the grand jury testimony came in, which I just referred to, and another witness who had, and the one witness that places him, with a gun shooting was a witness that, one, gave two prior grand jury testimony that said he had nothing to do with it. Two, testified at prior murder cases in Rhode Island. Three, had a prior murder case himself in Rhode Island. And now he's allowed to testify that, oh yes, my client, oh by the way, the third time, my client was the one who was the shooter. So I would say that the theory of the defense was it wasn't him, and the evidence was really, really weak in terms of who you got testifying against him.
Okay. Well, was one of the themes that he was a mild-mannered guy who didn't know anything about guns?
My guy?
Yeah. Was it part of that defense that he was your guy was a mild-mannered guy who didn't know anything about guns?
I don't remember that at all.
Okay. Well, that's what the prosecution says is the case. The testimony about the guns from Stevenson and Clouden was necessary to rebut your theme that the defendant was a mild-mannered person who knew nothing about guns. And I was wondering if you had anything to say about that.
Well, if he, and the only thing I could say is that if he testified to that, when Mr. Pierre testified at trial, it would have been way after these two people testified about the guns.
Yeah, but if there's a theme that he was a mild-mannered guy, he didn't know anything about guns. Isn't that kind of pertinent to whether or not the judge was acting within his discretion in allowing them to testify that they'd seen him with a gun?
Frankly, I would say yes if that's the case. I don't remember that being a theme at the trial. I really don't.
Okay, all right, fine.
And I really could be wrong.
Okay, well.
I don't remember that as a theme. I do remember, though, that these two guns all of a sudden show up and they're not the murder weapon. So what?
I understand that. Yeah. Okay. The next question I have had to do with the grand jury testimony. And the question was whether or not it was sort of prejudiced, even if you're right about the fact that it was a contrary deed today in the way it was done, how could it have prejudiced him as it was cumulative of Headley's trial testimony?
Cumulative as to whose trial testimony? The only
Headley's trial testimony. That's what the Commonwealth says.
Yeah, but that's not true.
Okay.
I mean, I beg to differ. The trial testimony, again, was from this guy named Johnson, who has, I know you have read it, and if not, you'll read it carefully again. He has a history of testifying at many trials. He gave 2 prior grand jury testimony under oath, which were, now he says, are not true. And he was charged with murder himself in Rhode Island and testified in the case in Rhode Island and got off on a case in Massachusetts for doing this, for testifying at trial. That's the evidence. So
Okay.
What's the heavy evidence at trial? That plus the day testimony? That's what you got. Well, you do have a guy in a white T-shirt. I mean, you also have a guy walking around in what they call, unfortunately, they want to call a wife beater shirt, and that language was repeated throughout the trial without objection.
Do we ever have what is the definition of a wife beater shirt, by the way?
Yeah, they said it was a shirt that, like had no straps, like a white T-shirt, sleeveless.
Or sleeveless.
It had straps, but sleeveless, yes.
And so it's the same thing. It's strapless undershirt and the wife beater undershirt, the same thing?
Yeah, that was the same thing.
Okay, all right. Now, you didn't file a reply brief, right? Because I'm looking for your reply brief to, and you didn't file one, right?
I did not file a reply brief.
Oh, good. I didn't lose one then. All right.
You did not lose it, no.
Okay. And then I wanted to ask you a last question about this, the comments that were clearly inappropriate. The Commonwealth concedes that he shouldn't have talked about the Boston to Trinidad stuff to try to clear his name and all the rest of that. But he says that the judge gave really good jury instructions at the beginning and end of trial about the presumption of innocence and the burden of proof, and they were just a small part of the otherwise proper arguments about the flight to Trinidad. So what do you say about that?
Well, he did give an instruction, and I referred to it in my opening. It's on. I just saw it on my brief, but it's toward the end of the fact section of my brief.
Okay.
And he did. But how he phrased it is it doesn't go. It's proper questioning as to. It's on page 34 of my brief. He says the questions that were asked and the answers that are given are admissible. I don't think they are, but they were admissible in connection with your assessment of the credibility of this witness. How? That's exactly what it shouldn't be. But it does say that the person accused of a crime has no burden of disproving the crime in any way. Okay. So yeah, he talks about burden shifting. But he also says you can consider it as to the credibility. Well, that line of questioning, and again, it was repeated over and over again.
You say over and over again. How many times are we talking about? 2 times, 3 times, 4 times? What are you talking about?
I didn't count, but it's probably more than 4.
Okay, fine. Thanks.
And if I'm wrong, please forgive me. But it was
sure.
It was multiple.
All right, multiple. All right, I don't have anything else.
Thank you, Justice Lynch.
Yeah, I have one question. Is it overstated to say there was a stipulation that this was not the firearm? As I read the transcript, it's more accurate to say that there was no direct evidence this was the firearm. Judge Locke finds there's no evidence that it wasn't, there's no evidence that it was. And the defense attorney says, I suppose, right. The Commonwealth says, well, we're not going to argue with that. But the distinction being in Tassinari and some of the other cases, the firearm in question was absolutely excluded. Here, could have been, could not have been. How do you respond to that?
When it first was brought up, it was clear that this was not the firearm. I noticed, and I think you're correct in stating this, as the trial progressed, the prosecution got, well, I don't think it is. Well, we have no evidence that it is. It probably isn't. And then the judge, wanted a clarification. But I think at the one point the judge finally said, well, if you're saying that it's not, it's not. So, I do understand what you're saying.
I'm reading from the transcript, volume 6, page 10.
Okay.
Where it's unambiguous. He says could have been, could not have been, and the judge makes his rulings based upon that, and the defense attorney agrees to that. We have a black firearm. We don't have, and it's a semi-automatic, and that's a black firearm is used. Tassinari and all those other cases, it's definitively not the firearm.
I would say, to answer your question again, if you read the entire transcript, this went in many different ways until the end. But what I would answer you and say this, there was no, I mean, I understand what your distinction is. Was it absolutely ruled out by ballistics evidence? No, it wasn't. But there is no evidence that those were the firearms. None presented at trial. And, the Commonwealth has the burden of proof. There was no evidence that these were the firearms. So, how do they come in?
You told us there was a stipulation. That's not true.
But there was a stipulation at the end. One of the stipulations entered into by the parties.
Give me a page cite for the stipulation.
Transcript 10.
Yep.
Page 63.
Page 63. All right, I'll look at that. I have no further questions.
Justice Louie.
Yes, Mr. Black, good morning.
Good morning, Justice Louie.
So Justice Link referred to a couple of issues where the defendant arguably brought up his character and not the type of person who would know anything about firearms. They were in the opening and the closing. The opening, you're going to hear evidence relating to this diabolical, psychopathic crime, and you'll hear no such character evidence relating to my client. And then in the closing, which I guess really doesn't matter because the rulings have been made already, but the defendant says that, defense attorney says my client's milquetoast, doesn't know anything about firearms. So did the defendant sort of insert character evidence into the case? Because the Commonwealth, actually in the first part of their brief on this issue, is saying, well, yeah, it is character evidence, and they pivot and say it isn't character evidence.
Well, I have a couple responses to that. One of them, I'm not sure how to say this in a nice way, but probably would have argued the case a lot differently if it was me. I think trial counsel made several mistakes, and that might have been one of them. But I would also say this, that opening and closing obviously are not evidence. And, they're not. And judges give that instruction all the time. I don't know, exactly where he was going with this. But they shouldn't have been allowed it. They shouldn't have been allowed it. Maybe they should have been allowed to Bene. I don't know. But introducing it to rebut what was said in an opening, I think was improper. And to show what? That he wasn't milquetoast? And that again, so what you're saying is he implicitly introduced character evidence by saying he was milquetoast, although again, that wasn't character evidence because there was no evidence. And then they were allowed to rebut it by showing two firearms, which you tell me how the jury was going to react to that. There was no way that they were going to react to that in a neutral way and in a way that wasn't showing that this guy was a bad guy. What you got here, when you look at the whole case with the firearms, with the day testimony, with this guy Johnson, that's what you got. You got some really bad witnesses, some really weak witnesses with a huge amount of motive. And you got two firearms that were stipulated that there's no evidence. I'll put it this way: there's no evidence that there were the firearms in general.
Well, we'll have to look at the transcript. I agree with Justice Graziano. It's hardly clear, but we are reviewing this firearm issue, even though it's preserved for an abuse of discretion. But I don't know if you had a chance to look at Commonwealth versus Andre, but the concern here with the prior firearms is they also involved a violent situation, and whether or not the firearm was used in the crime, that's not the end of the analysis here. From your perspective, although I'm not sure you've said it precisely this way, you'll tell me if I have it wrong. From your perspective, the undue prejudice of the firearm is that this is an ID case and that the jury might have made an ID based on the prior possession of firearms.
And I did not precisely put it that way. Thank you.
But do you agree with that analysis?
I do.
Now,
I mean, it is an ID case.
Okay, and that's when the concern with the prior firearms is at its zenith, right?
Yeah.
So on
one concern.
On Commonwealth versus Day, the whole issue of coercion comes up on cross-examination, and there's no voir dire, and it's up to the judge as a preliminary question of fact to decide whether he believed it was coerced or not, and the judge found Day was satisfied. So, what precisely are you saying was the error? It doesn't go to weight, but the error in the admission of the prior inconsistent statement under oath here.
Well, he didn't go as you just described. There are four elements of Day, and he didn't go point by point by point by point. He didn't. He just said at the end of the day,
they're all satisfied. They're all satisfied, inconsistent, under oath, not coerced from the judge's perspective, and not a mere confirmation or denial. So all four are satisfied, though.
Well, he testified he was coerced.
I understand that. That's why I asked you initially, isn't it? That came up on cross after the ruling without a voir dire, and isn't it up to the judge as a preliminary question of fact as to whether or not he believes the testimony was coerced in the grand jury?
I mean, I would agree with you that I guess the judge did make that implicit finding, but he didn't explicitly make that finding. I mean, the first point you mentioned was he subject to a meaningful cross-examination? Well, he said, I don't remember saying any of this.
So he's cross-examinable on the prior statement because he's denying saying it, and that
he's denying saying it. But I think the case in Day, the guy remembered saying it, and when they were able to cross-examine him as to what he testified to, and in this case, he was not able to testify. He didn't remember anything, and he said he didn't say it.
Right. Well, I'll move on. I have one more area of inquiry. That's going to go to the feigning issue. I'll ask the Commonwealth about that. Neither you nor the Commonwealth on the failure to impeach the witness with the pending federal charges cite to Commonwealth versus McGee, which is our most recent discussion of this issue in 2015. But there has to be a foundation of, at least a hope of finding more, getting a more lenient sentence or some sort of promise, furnishing some explanation that's persuasive that the pending charges of the arrest might indicate a motive to lie. Was that foundation ever satisfied in this case?
Well, I would argue this, and I did not cite McGee, but I would argue this and I cited Davis versus Alaska in just about every case that this has come up with since I was practicing law, and in almost every case, I got a ruling. I think every case I got a ruling that was proper cross-examination because, and especially in federal court, where every little thing counts off your point total, and when they're computing your sentence. Cooperation certainly counts, and Davis versus Alaska says the hope, the mere expectation and hope that you're going to get some benefit, period, is proper cross-examination because it goes to bias. And you can argue bias at all times. You can argue bias in front of the jury in closing argument. This guy was facing a $400,000. And $400,000 in federal court's a lot of money, and you get more more sentence as much, that the more money you are involved in. It's a lot of money. I don't know what he was facing, but he was facing federal time. And it certainly, I think, under the Sixth Amendment, was absolutely appropriate cross-examination. I don't understand the withdrawal of the motion. And, the judge started going that way. The judge first said it's not related. At the very end of the argument, he started saying, well, it's possible.
All right.
He was hoping for something.
Thank you very much, Mr. Blatt.
Thank you very much.
Justice Hood.
I don't have any questions.
Justice Pfeiffer.
Thank you.
Excuse me. I don't have any questions either. Thank you.
Justice Cass.
Thank you.
Same for me.
I've got only a few. The stipulation you mentioned at 106263 is a stipulation that the Taurus semi-automatic pistol that was recovered from Mr. Fenton was indeed the murder weapon.
Yeah.
But it doesn't say that the firearms he pulled out before Stevenson or Clouden were not, and indeed I recall that didn't Stevenson say it was a semi-automatic? It had a clip?
I thought she said, let me see, it's right in front of me.
That's page 114. She described it as having a clip.
Sorry, I'm trying to pull it out here.
Well, trust me.
Oh, no, I believe you. No, I'm not believing you, but I just read it, and I thought you said something about it, that you had to pull a trigger. Oh, God.
And page 113, yeah, it was a black handgun. It's not one with a revolver. It's one that you would click. Click OK. When you say revolver, what kind of a gun? The kind of gun with a barrel? Yeah, that's what a revolver is. Yeah, it was not that kind. Exactly. It's the kind where you put the clip in the bottom.
Okay. All right. That's what you said.
So, and this was a semi-automatic, I guess. It was a black semi-automatic?
Yes.
So we can't say that it. In some of the cases Justice Gagliano was referencing to, it was a revolver versus semi-automatic. They clearly could not have been the gun, but this at least was consistent with the gun. Whether or not it was the gun, we don't know, but it was at least consistent with it, correct?
Well, the way, when I read the transcript, and it was a long time ago, but I remember that the district attorney at one point in the trial kept on saying, we are not going forward with the theory that these were the firearms.
Right, well, they certainly can't prove it. They couldn't prove
it.
Right, I understand that. They were not going to be able to prove that that was that yes, it was a black semi-automatic that at least Stevenson saw. I don't think Clouden described it beyond its color, but yeah, they couldn't prove it was the firearm. But that's different from saying it plainly was not, which they could have proven if indeed it had been a different type of gun.
Okay, I would agree with you.
As to the testimony of Mr. Leacock, am I correct that his grand jury testimony preceded his indictment in federal court?
Wow. I can say with certainty that I do not remember that.
Okay, because I had some memory in the briefs, and we'll find from Mr. Lynn, because if that were the case, then if he were to be impeached with his federal criminal charges, then they could try to rehabilitate him by saying that that's what he said in the grand jury before he was indicted. So that would be a reason to not press the issue, if that indeed were the case. And I guess we'll find out from Mr. Lynn whether that was the case, correct?
Correct. And except none of that is, but yeah, I agree with you if that's the case, but none of that was on the record.
Okay. The date of the indictment was not in the record during any of the discussion about the motion?
I don't remember, no. Not for Leacock. It was for everybody else who was testifying to different indictments and different grand jury, but I don't remember it as to Mr. Leacock. But again, this was a long time ago.
Okay, I have no further questions. Anybody else have any questions? Having concluded the questioning that's in order.
All set.
Justice Gaziano, anything? Justice Lowy?
No.
No, thank you.
Okay, hearing nothing. Mr. Black, thank you. And now we'll hear from Mr. Lynn.
Thank you.
Thank you, Mr. Chief Justice and Justices of the Court. May it please the Court. Turning to the first issue, I'd like to start at the very beginning, which is the opening statement in which defense counsel argues that this murder was vile and diabolical, and you won't hear any evidence that the defendant fit that personality. And that was a bit disingenuous because, of course, the Commonwealth cannot introduce evidence of the defendant's character. But both Hawley and Tassinari, which I read, do say that you can still introduce a gun to show familiarity and knowledge of guns and the means to commit the crime, even if there's no direct evidence connecting the gun to the crime. And that's the situation here. Hawley, in fact, is very closely on point because, again, there you have a gun that's generally consistent with the murder weapon, but there's no evidence that it is, in fact, the murder weapon. In fact, it could have been any number of weapons that was the murder weapon, because I think in that case the murder weapon was not found. Also, the judge, I believe on both occasions, but at least on the first occasion, instructs the jury that they are absolutely not to consider this evidence as evidence of the defendant's bad character or propensity to commit the crime. It's solely for the purpose to show his knowledge and familiarity with guns. I also point out, I just read this last night, there is no evidence that the defendant threatened anyone with these guns that Denise Stevenson and Chaka Clausen saw. Stevenson testified that the defendant was playing with the gun, and at one point he playfully pointed it at her, and she responded angrily that he was pointing the gun at her, but there was no suggestion that this was a threat. It was just something playful that she took reasonable objection to. And Mr. Clausen simply said that he displayed the gun. So there was no evidence of any threat or violence or slapping it down on the table. So in light of all those circumstances, it was well within the judge's discretion to admit the evidence that Stevenson and Clausen saw this gun. Turning to the day issue, Jonathan has a reasonably clear memory of the night of the murder when he testifies at trial. He doesn't remember everything. He answers a lot of questions with I don't know, but he does affirmatively repudiate his grand jury testimony. He says he doesn't remember what he said, but he didn't see the murder. He was just coming around the house, and when the shooting started, a friend ushered him back behind the house. He didn't see who was doing the shooting. He tells a coherent story that's completely inconsistent with his grand jury testimony. The day itself says that there could be no better cross-examination than the witness changing his story and saying the story he told at the grand jury didn't happen, and that's what Johnson did here. Regarding the questions about whether the defendant came back from Trinidad to clear his name, as we've all agreed, that was an improper line of questioning under Gardner. Prosecutor shouldn't have done it, but the judge responds by doing exactly what he's supposed to do. He breaks in. He says, no, the defendant has no burden to clear his name. The burden is always on the Commonwealth, and he even harks back to the instructions he gave to that effect in his opening remarks to the jury, and then again he repeats that, of course, in the closing argument. And for the record, it's 3 times. The prosecutor asks the defendant 3 times whether he considered coming back from Trinidad to clear his name. Turning to the cross-examination question, the reason that defense counsel decided not to use this evidence, excuse me, I think I have my timer on, and I'm going to turn that off for the the reason he says, the reason he decided not to do this is as long as it's consistent with his grand jury testimony, because his grand jury testimony was before he got this new federal charge. I don't have the exact dates in my brief, and I don't remember what the exact dates were, but that was the issue, that as long as Leacock testified consistent with his grand jury testimony, there was really no worth to this evidence of this charge, because it obviously didn't affect his story. And it is, and I cannot emphasize this strongly enough, defense counsel's decision. The judge does, as my brother said, come around and say, well, actually, yeah, he might have something in the back of his head about maybe currying favor with the Commonwealth, so you could address that. And that's when defense counsel says, no, I don't think so. As long as I think it's not going to be, all he says is, he doesn't really explain it. I don't want to put words into his mouth, but he says, I think I'm going to withdraw the motion as long as his testimony at trial is consistent with his grand jury testimony. So this is not like Davis versus Alaska. This is not a judicial restraint on cross-examination. This is a decision by defense counsel. Defendant doesn't raise an ineffective assistance of counsel claim, and I address it in my brief why it is an ineffective assistance of counsel. And with that, I will turn the issue over to you, the justices, to ask many questions you have.
Okay, Justice Link.
Good morning, Mr. Lynn.
Good morning, Justice Link.
Good morning again, yes. I would like to just go to the day issue a little bit here. Now, it wasn't until cross-examination that they came out from Johnson that the police had coerced him to testify to the grand jury, right?
That's correct.
And the judge had already ruled on the fact that the grand jury testimony could come in, right?
I'm sorry, I missed that.
Did the judge at that point, the judge had already ruled that it could come in, yes?
He had already ruled that it would come in. There was no break in the action when Johnson gave that testimony.
Yeah. I guess my question really has to do with whether or not the judge had some obligation after the police, after Johnson testified to coercion that he hadn't testified to before. Did the judge have any obligation to reconsider it sua sponte? Because that's really because the defense didn't ask him to do that, right?
No, the defense did not ask him to do that. I don't know of any precedent for the judge breaking in the middle of day testimony to reevaluate the situation. Certainly would be addressed under the miscarriage of justice standard, and there was no miscarriage of justice here because the defendant, or excuse me, not the defendant, Mr. Johnson completely repudiated his grand jury testimony. He said, I just didn't see the shooting. And he explains it. He says that's how he explains why he gave the testimony, is because he was coerced and because he heard it on the street. He heard it from Leacock. He heard it from somebody else. By the time he's done testifying cross-examination, he has made his claim that his grand jury testimony had no integrity whatsoever. Commonwealth obviously disagrees with that and wasn't have to argue that, but he certainly, Johnson, that is, certainly by the end of his testimony said this is not what happened.
Yeah. So you don't see any possibility of a miscarriage of justice in the defendant's failure, the counsel's failure to ask for reconsideration of the credibility issue?
No, none at all, for the reasons I just stated.
Okay. I don't have anything else. Thank you.
Justice Gaziano.
I have no questions. Thank you.
Justice Bowie.
Mr. Lynn, good morning.
Good morning.
I want to ask you about the firearm. So it seems that it may have been the same weapon. It may not have been, but that's not the end of the analysis. I guess my question goes to the issue I raised with Mr. Black. Because the defendant inappropriately raises character evidence in the opening statement, doesn't allow the Commonwealth to violate the rule against character evidence. And the concern here is that the prior possessions of the firearms would be used for identification purposes at trial, since it's an ID case. What's your response to that?
Well, several. The first is the Commonwealth, obviously, as I conceded in my brief, can't fight fire with fire. And in fact, the prosecutor tried to bring in evidence that the defendant had said, "I'm a gangster, I can take out people," and the judge rightly said, "No, that's just plain character evidence. You can't bring that in, no matter what defense counsel said in his opening." But where the defense counsel says in his opening that the defendant doesn't have the character to commit this crime, where he says in his, obviously it comes in before the closing argument, but this is a theme of the defense. The theme of the defense is, my client isn't the kind of guy who would commit a triple murder. And regardless of whether that's appropriate for defense counsel, the case law is clear that the Commonwealth has the right to correct an erroneous impression. And the judge here balanced that very carefully. He gave this instruction over and over again that this couldn't be considered as evidence the defendant committed the crime. The jury couldn't consider it as evidence of bad character. They could only consider it to show that he was familiar with guns, had knowledge and familiarity with guns, and the means to commit the crime, which under Hawley and Tassinari is entirely proper and well within the judge's discretion. And as I said in my opening remarks, there's no evidence that the defendant used this gun for any violent purpose. At worst, he was being reckless with it, but he never used it to commit a crime. He never used it to threaten anybody with. It's not especially prejudicial evidence.
All right, thank you. One last area of questioning is the failure to impeach Leacock with the pending federal charges. Mm-hmm. Here, the defendant, there needs to be some, at least, strategic reason not to do so. And I think the chief raised the point that, and it's my understanding as well, that the grand jury testimony predated the grand jury testimony was before the statement at issue, and I guess there's an issue of prior consistent statements there before the issue of the federal indictment.
Mm-hmm. Yes, Your Honor.
Yeah, because if the grand jury testimony was before the federal indictment, there would have been a strategic reason not to ask the line of questioning, right?
Correct, Your Honor, yes.
Okay. All right, that's all I have. Thank you very much.
Justice Budd.
I have no questions, thank you.
Justice Safer.
I have no questions either.
Justice Kafker.
The same.
And I guess I have one question. With regard to the prosecutor's statement, I assume there's guidance in your DA's office which is telling people they shouldn't do that.
I certainly hope so. It's one of the things we tell people not to do. It's the problem, I assume, is that the federal law differs from the state law. That doesn't excuse what the prosecutor did, but I assume that is the source of the error. That you could look at the federal law and not jeopardize it and not realize, unless you were up, which we all, of course, are certainly obligated. We have a duty to be up on the law, that you could make that mistake. So I think that's what happens. It was an unfortunate mistake. We can see that it was a mistake, and yes, we constantly, continuously, we have a training requirement. We have closing argument trainings. We have closing argument manuals. We certainly take this issue with the utmost seriousness.
This trial was what year? It was 2000?
Oh, it was late. It was 2017, maybe. My screen has gone blank. I apologize.
It was that recent.
Yeah, it was because the crime was a long time ago, but it took a long time to extradite him from that. That was one more point I want to make about the argument. It was entirely proper for the prosecutor to argue consciousness of guilt based on the fact that the defendant went to Trinidad 3 days after the murder and never came back, even though he had a return ticket. Let's see, where's the exact date? Excuse me, I'm sorry, it's not that late. It's 2014. is the date of the trial.
I mean, Mr. Lee, I believe, actually defended what he did for the reasons you described. That it doesn't.
Right, it's pre-arrest silence and post-arrest silence, but that's clearly contrary to Gardner, which I almost certain, and certainly Nickerson, I think, is the case that was before that said so. Gardner, what was Gardner? Sorry, I apologize for this. Gardner, actually, in his defense, Gardner wasn't until 2018. But there was still Nickerson in 1982. So it's the only defense you would say is that you could say that the Supreme Court overturned Nickerson, but I think that would have been a rather bold assumption.
Right. Okay. I mean, I'm not even sure what was the inference he was trying to make.
Well, the inference he was trying to make is that he said that I should be clear with my pronouns. The defendant said that he stayed in Trinidad because everyone thought he did it, and he was afraid. And he was, at one point, he says he was hoping the police would do their job and find the real guy who did it. So he's trying to say, so you're innocent. You're being charged with murder. The inference was, any person in that situation, would try to clear their name, and that's it's a reasonable inference, but unfortunately an unconstitutional one. So that's when the judge stepped in and said, no, the burden is always on the Commonwealth. The defendant has no burden whatsoever to clear his name at any time.
I don't even see how it's a reasonable inference. What's he supposed to do?
Say I didn't do it, but I mean, yeah,
he could do that by telephone calls from Trinidad. All right. Well, I guess we're beating the horse,
we can see the error. Yeah.
Yeah. It should not happen. It should not happen again. And if you'll make sure that it's a matter that is a subject of discussion at the next training, I'd appreciate it. Any further questions?
I have a question on that last point, Chief. Ms. Lynn, isn't the relevance that which was inappropriate, as you say, was that, well, this witness has no credibility because if it was really true, he would have come back. And that might be relevant on the issue of credibility, but it's inadmissible because it infringes on the defendant's right against self-incrimination, right to remain silent.
Exactly right, Your Honor. And that's why it was very important. We'd be in a very much more difficult situation if the judge had not done the right thing.
Well, yeah, I mean, he was a very good limiting instructions, a very experienced judge, but he allowed it in on the issue of credibility, and it was not admissible on the issue of credibility.
My interpretation of the instruction as a whole is that he was referring to the consciousness of guilt evidence in general. But the fact that the defendant went to Trinidad 3 days after the murder and didn't come back on his scheduled date was properly relevant to the defendant's credibility as consciousness of guilt evidence.
Oh, okay.
If there was any suggestion that it was also relevant to his credibility because it showed, that he didn't come back to clear his name, that was addressed in the rest of the instruction, where he says you absolutely, positively cannot consider it for that purpose.
All right. Thank you. That's helpful.
Right. And for those who can't do voice ID as well as I can and my fellow justices, the questioning was by Justice Lowy. Any further questions? And hearing none, Mr. Lynn, thank you. That will conclude our oral argument. We shall commence our ensemble in about 2 minutes. Thank you.
Thank you.
Thank you, Your Honor. Thank you.
Now exiting